Thank you everyone for joining us. We're ready to get started. So today's session is on understanding Illinois' child protective system. And Illinois' Department of Child and Family Services defines itself as having the primary responsibility of protecting children through the investigation of suspected abuse or neglect by parents and other caregivers. And in practice, that creates a complex system where investigators are investigating thousands of parents each year, and it has a multitude of legal implications for parents and their children and our community. And so we have the pleasure of having Kimberly Mills with us to give us an overview of that system and insight into how it works, reforms that are on the horizon, hopefully, and problems that end up popping up. So Kimberly currently works as an assistant public defender at the Cook County Public Defender's Office. Before that, she was at Cabrini Green Legal Aid as a supervisor attorney of the Criminal Records Program. And back in 2015, Kimberly was a school year Pili intern at LAF, which is now Legal Aid Chicago. So welcome back to Pili, Kimberly.
Thank you. Thank you for having me. Brent already told you guys a little bit about myself, so I'm going to just skip that and we're gonna just get right into it. If I can figure out how to use my computer. Okay. So this is going to be kind of an overview of the child protection system. And so I'm going to first kind of just dive into what the purpose of the system is, and then kind of break it down into how a family becomes involved in the system, and then what happens with a case. So once you're in the system, what's kind of the path? And throughout, I'm probably going to throw out some questions. I tend to do that, and we're gonna test my Zoom skills here. And I believe you can just, I think, Brent, correct me if I'm wrong, but there is like a chat feature that you all can type them in, or if you raise your hand, I will then look out and acknowledge. Okay. So feel free to interrupt if you have questions, comments, thoughts, concerns, anything like that. All right, so first is the purpose. And so the purpose of the system is first to investigate allegations of child abuse and neglect. And we'll talk about who does that and what those investigations kind of look like. The second purpose is really where the bulk of the work is focused on, and that's to provide children and families with the resources, tools, skills, services, etc. necessary to successfully reunify. These are courts of reunification, so they're not courts of punishment, which is something that we often have to talk to our clients about. And even though it is a court of reunification, sometimes it can feel punitive. So that's something that we absolutely are constantly trying to remind other parties about, that we're here. The purpose is to reunify families, not punish parents for whatever challenges they're facing. And then finally, the purpose is to achieve permanency for the kids. And permanency means what it says, right? It's a permanent a place. We hope that permanency is achieved with their families, but sometimes that's not always possible. All right. So this is just a quick overview of how a case comes into the system. So the first thing that happens is the DCFS hotline is called. So mandated reporters, those are gonna be police, teachers, babysitters, basically everyone. We are not mandated reporters for confidentiality reasons, which can be challenging at times, but is important kind of for upholding our professional duties and responsibilities and the integrity of the law. So anyone can call the hotline. The other kind of unique I guess, person that calls the hotline sometimes are parents themselves. And parents call the hotline for two reasons. Sometimes they need help with their child or their situation, and they don't fully understand that by calling and involving DCFS, they're kind of almost telling on themselves, and that usually it's because they're not aware of maybe other social services out there that can help them kind of achieve what they're seeking. But the other is, are parents who have kids with significant special needs, whether that's behavioral or mental health or physical, and they need assistance from the state. And so we call those dependency cases. So those are cases where parents are not at fault, but they will be found like what they call unfit, or unable, to take care of their child. So kind of our classic case, and one, I mean, I've had 3 come in the past probably 3 weeks, are young kids who are very mentally ill, and it's starting to manifest between ages, 13 and 16, 17. So homicidal ideation, suicidal, things like that. So that is, that's the dependency case. So after the hotline's called, an investigator goes out, and that's kind of when I'm talking to my clients, it's like now you have somebody who's just all up in your business. They're asking questions of you, of if there's another parent involved, other family members. They are getting as much information as they can about the child, the situation, and what's going on. The investigator then does kind of a report, and there are 2 options. The case is either what we call unfounded, which means, whoops, our bad, this actually isn't a case of abuse, neglect, or a dependency case. And in that situation, the parents can actually expunge that kind of record, but it is a process that many people aren't familiar with. So unfortunately, DCFS sometimes ends up holding on to them, and it can come and kind of bite clients in the rear if they come back into the system. For cases where the investigator does believe that some action needs to take place, the report is called indicated. And so that means that a parent has been indicated for abuse, neglect, or dependence. And this is where, when we talk about this not being a court of punishment, it feels like punishment because a lot of times clients are like, well, I was, they're accusing me or they're trying to say I'm guilty of abuse or neglect, right? And so in terms of client counseling, it's super important that we effectively communicate kind of what the process is and what's happening. So if the report is indicated, then there are 2 options. The first is something called an intact case, and that basically means that DCFS is going to try and work with the family outside of the court system to provide them with resources. They'll put in a safety plan, so kind of if X then Y type situations and scenarios. And they're going to do a very minimal level of monitoring. So they're going to kind of check in and make sure that the parents are kind of doing what they're supposed to be doing, and that the kids are getting what they need. Failure to comply with the intact kind of case can result in a court case. There recently, I know there was a question that was passed, that was Brent sent to me from someone about kind of what reforms can we do within the system. There was a recent DCFS policy that kind of infuriating, that basically said, if this is your 3rd indicated report, so we do kind of the alphabet sequence, so A, B, C, if this becomes a C sequence, it's automatically considered a court case, regardless of if it is for something piddly, it is automatically a court case. And so we're seeing right now in the child protection system in Cook County, an huge increase in the number of cases. Right now, I think I have a case, we're already at over 1,000, which typically, this is July, we usually don't hit 1,000 cases until like September. So we're September, October. So we're, they're just, I mean, we're becoming pretty burdened with them. So the court case. All right, so basically the investigator has to go to the state's attorney's office, fill out a form that says we believe this case needs to kind of move forward into the process. I'm so sorry, one of my dogs is barking because the other one is on the other door. We're gonna just try and ignore her. So the first step, once the case is filed, the state's attorney will file the case. The very first step is something called a temporary custody hearing. And I'll get into some of the details and kind of the highlights and lowlights kind of after we go through this portion. Then we have a bunch of status dates. We have something called the court family conference, which is a bit different and unique to the system because it's an opportunity for all of the, oh my gosh, hold on. Lily, can you stop, please? Stop, come here. I'm so sorry, she's so embarrassing. For the judge, the attorneys, everyone to come together and discuss the progress of the case and what's happening. A case management conference, it sounds very fancy. It's not, it's kind of a pre-trial stage. Adjudication is another word for trial. And adjudication and disposition are what we really spend a lot of our time on. Adjudication, I always describe it as, you know, for the reason the case came in, did that or did not happen? The judge is going to determine whether or not the kid was abused, neglected, or dependent. And I always tell parents that focuses on the past, right? That's the incident for why this case came in. But what we're going to focus on, if in certain situations, sometimes we can contest things at trial, but is the disposition, because that's focusing on what the parent has done since the case came in. So have they complied with services? Have they been visiting with their kid? What are the things that they've done to show the court that, per the court's words, corrected the conditions for which the case came in? So, you know, adjudication focuses on the past, disposition focuses on the future. Then we have permanency reviews, which I'll explain what those are, termination of parental rights if we unfortunately get to that point, and case closure. Any questions before I keep going? No, I think we're good. Okay. Brent, if you don't mind, if you see questions come up, if you could just help me monitor, that would be
For
awesome.
sure, we'll do.
Cool. So a realistic timeline of the case. So I'm sure, you know, as you guys are getting into your experiences and you know, in certain areas, things move much faster. And in others, it is just a glacial pace. Child protection, it's glacial. And so really a case, this is just kind of an overview, but the short version is a case, you know, you're looking at probably anywhere from, you know, 10 months or 12 months, about a year, to some cases. I mean, I saw one today that was up in one of the courtrooms I was in that came in 2012. So unfortunately, they can linger. So the parties in the courtroom. So there are a ton of people in the courtroom. There are your state's attorneys. There are also your guardian ad litems. And so those are the attorneys for the children, but they have a dual role. And the Juvenile Court Act in Illinois, it kind of, I personally, I mean, I think maybe not the best written portion, but it has a dual, there's a conflict, because you're supposed to be the attorney for the child, but you're also supposed to represent the best interest of the child. Does anyone have any ideas as to how that might be problematic?
What the child wants, which is what an attorney's role would be to follow, is not necessarily the same thing as what the child's best interest is.
Absolutely, absolutely. And so that's correct. If someone wants to go home with mom, but mom, it's not in their best interest to do that, there is that conflict. And so the guardian's job, the way that they've kind of, I guess, reconciled the issue, is that the guardian has to alert the court as to what the child wants and what the best interest, what they believe the best interest is. Then you have the public defenders. So we represent the parents. We also have a conflicts division, and that's actually the division that I'm in. So every parent, regardless of if they're married or not, gets an attorney, a separate attorney. On occasion, there are times where the judge, since often my division, on the conflict side, we usually get the second parent. So we get a lot of dads. And sometimes if there are multiple dads that have the same interest, we will be appointed to represent all of the dads. So, I mean, I don't know how kosher it is, but it happens. I have one case where I represent 3 of the dads. And so far it's okay. You know, there's not, when the judge tells me to do it, there's not a whole lot I can do in that moment other than run it up the chain. There are also bar attorneys. So those are, if you run out of, you know, after you have your PD, your conflicts PD, and you still need another attorney, there's something called bar attorneys. They're privates that you clients don't have to pay for. They're paid for by the court. And then DCFS has a legal representative. They have an attorney there as well. Then the rest are kind of traditional, your judge, your court reporter, court coordinator, deputy. The parents are, and the children are parties to the case. Children are usually not present, and that's intentional. Sometimes if they're older, they are allowed, but usually they're not there. And foster parents aren't automatically parties. There are, anytime a foster parent tries to come into a case, I always make a motion to exclude them, mostly because if we're talking about these intimate details of someone's life, about things that brought the case in and what their progress is in the services that they're getting, in order to protect my client and their privacy, and in some respects, their dignity, I ask that the foster parent not be in the courtroom. And then we have these, you know, social workers. So your investigators, also your caseworkers, and sometimes there are CASAs. So the first stage, so kind of going back through to walk kind of through each part. So temporary custody. So case comes in, let's say a baby was born drug exposed, mom also tested positive for opiates, dad admits to substance abuse, refuses to take a toxicology report, and also discloses that they are homeless. This is like actually a case I have starting at 1. That's very much the fact pattern. And the first point of the court hearing that is at temporary custody. And so the judge has to make a determination of 2 things: whether or not there's probable cause that what is stated as the reason for the case coming in did in fact happen. And this is a very, very low threshold. I mean, it's a feather's weight. It is rare for us to be able to challenge probable cause. It's been done, I've done it, and we celebrate those moments when we're able to do that because it's so rare. The bigger factor or bigger question that the judge has to answer is whether or not there is urgent and immediate need that the child be removed from the care of the children. I'm sorry, of the parents. If the judge finds that they have to be removed, then the child is officially in foster care. Now, foster care, that could be with, hopefully it's with a relative, which we call a relative placement. But if that's not available, or if a child needs, you know, specialized care, then it can be a traditional placement. So this is just, I'm gonna kind of go a little bit probably quicker through some of these like overview slides. You can glance at them, but I wanna make sure I leave time to talk about kind of COVID's impact and to open, you know, if we're able to have a bit of a discussion about that for the last maybe 10 minutes or so. So this is just, they have to be, the hearings have to happen quickly, and that's because oftentimes the children are already removed by the time the case comes in, because DCFS has the ability to take something called protective custody. If they deem that the situation is unsafe, then they're able to remove the child prior to court. So this is just like a quick overview of what happens. I remember when I was just starting out, I kept, you know, thinking to myself and saying, well, what actually happens when I get to court and who do I talk to? And I will tell you, if you haven't already kind of experienced this, it's a lot of fake it till you make it. Everyone's doing it. I've also realized, you know, everyone's been in that position. Everyone's been yelled at. So when it's your experience, it feels, I don't know, worse. Your face turns beet red, the whole thing. But ask questions, find friendly faces, and ask for guidance. That would be kind of my my tip of for those that are going to litigate. Yeah, so it's you're going to get information as quickly as you can once you get to the courtroom, and try and talk to your client. Sometimes judges are going to like rush you, and you just kind of have to kind of say, Judge, I need a minute. I need to talk to my client before I can proceed. So then we have these status hearings. And so it's really there to check in. Was a caseworker assigned to the case? Every case after temporary custody is taken, if it's taken, there has to be a caseworker assigned. So this is the person who's going to ensure that the parents are referred to various service providers for assessments. So the usual services that parents are referred for are a substance abuse assessment, domestic violence assessment, mental health assessment. Sometimes there are things like, you know, it can get more granular parenting capacity assessments. So those of you at Equip for Equality, you know, it's a lot of those same evals that you're seeing as you're probably working with clients who have various disabilities. Those same evals are then done, and then clients are recommended for services parents. They'll also evaluate the kids, and if they have any needs that need to be addressed, they'll do that as well. Every single parent that comes in that has a case, there are 2 services that they have to do. It is just, I don't know why, but it is automatic, and that is individual therapy and parenting classes. So the way the hearings, these statuses work are that they're super quick, sometimes 30 minutes, 15 minutes even. The state or the guardian is the one who's leading it, unless we as the PD ask for it. The cases where we'll ask for it are like if a caseworker hasn't been assigned and we need a record saying that you have failed to assign a caseworker in a timely manner, then we would lead it. And then we ask for something. So, you know, what do we want the court to do? Do we want them to issue an order that says you have to assign a caseworker within 24 hours, you know, or you have to address placement of the child within 48 hours, etc. So then we have these court family conferences, and these are what's a little bit different about child protection court. And so it's, you know, it's really a check-in of how is it going? What's been going on? It's for the judge to get an update on services, to put in some deadlines for when things need to happen if they haven't already, and for us to kind of get a game plan for what's moving forward. So then we have these case management conferences, and this is really, I was trying to find some samples, but I realized I didn't have, the state sends us PDFs, and I could not figure out how to redact in order to kind of show you what it looks like. But it's kind of, if you look at, for who's at CGLA, kind of that first page of an expungement petition, or others who are familiar with it, it's kind of a graph or a table, and you fill in every single witness that you intend to call in the case, and the state prepares it, and then all the parties have to sign it. So it's your notice that these are the parties that are going to be called, and then if you want to add anyone, you can. One of the unique things I will say about child protection, for those who are interested in criminal, a lot of times, or if interested in the public defender's office, at least in Cook County, a lot of a lot of people when they first start out are placed in the civil division and are like super bummed out about it. I was not. I think I was placed in a worse division, which was the police station representation unit. I look back, I'm glad it happened, but it was rough. It was shift work. It was running around to police stations and kind of telling people, don't talk to anyone, sign this form, we're letting, you know, we're interrupting an interrogation, etc. But you are really seeing people at their just absolute worst. I mean, it's within hours of an arrest. And so, you know, working weekends, it was just not, it was not as in, you know, not what I thought I was signing up to do. However, civil is also what a lot of people don't feel they're signing up to do. I then let the powers that be, I guess, know that I was interested in doing this work. In addition, I went to law school at Tulane, and then I got an LLM in child and family law from Loyola. It's a long story, but if anyone's interested, let me know. And through that, I was involved with the clinic. So I know some mentioned working at Loyola, like Health Institute, or with Anita in the Legislative and Policy Clinic. I spent a lot of my time in the clinics. And so I worked with Bruce Boyer. And I remember in that guard where the students are, their guardian ad litems. And I remember when I was doing that, I kept thinking about the parents. I wanted to know like what's being done for them, what's important, how do we kind of address these issues in a way that focuses on both the kids and the parents. And so ever since having that experience, I wanted to kind of get back into it, but from the role of doing parent representation. So anyway, so that's why I think it's cool to be here. But what I was going to say is for those interested in criminal, child protection and here in Cook County, it's called Homicide Task Force, are the only places where you have the opportunity to do things like depose doctors. So again, those working in, you know, anything, I'm not sure how much work Lifespan does, but where you're getting kind of volumes of records for clients and going through medical records and evaluations and all of that stuff. This within the PD's office, this unit, if you like that, might be something to keep your eye out for. So adjudication, so this is the trial. So, you know, was the child abused, neglected, or dependent? Sometimes we go to a full-blown trial, or sometimes we stipulate to the facts. And so the state's attorney will draft like basically you can think of it's like a summary judgment motion or like a plea deal. So it's basically the trial on paper that if we brought in X, Y, and Z witness, they would testify to A, B, C, D, E, F, yada, yada, yada. And if everyone's in agreement, we sign it, and then we move to the next phase. But these have to be done within 90 to 120 days after TC. And you know, this actually is a good point to pause for a moment and talk about the impact of COVID. Even with that pre-COVID, one of the things that we would do is there's something where we can waive the 90 days so that the case is set further out than 3 months from when the first came in. Any ideas as to why that might be helpful for clients, you know, with addiction, mental health, any of those issues? Any ideas why it might be in the interest of a parent to waive the 90 days? Oops. Any ideas?
It just gives the parent more time to start engaging and participating in services to show the court at the disposition phase.
Exactly. That's the money answer. Absolutely. So, you know, pre-COVID, that was depending on the case. Sometimes there's litigation strategy behind, you know, not waiving 90 to try and get an earlier court date, et cetera. But that's exactly correct. With COVID, you know, what do you all think are some of the challenges that defendants and parents are facing with kind of a virtual hearing or a virtual trial? What do you think some of the issues might be that would present themselves? kind of virtual versus in-person.
Hey, I think one of the concerns that folks have is privacy, especially because, like, you know, in court you could make sure that you know, testimony is safe, but in someone's home it's not exactly the same, and you don't know who's behind the camera. So
Absolutely. 100%. There was, so our big boss, Amy Campanelli, the PD, she actually sent out this big memo to all 420 of us, stating exactly that, you know, that we're kind of in this tough position of, we want to move cases forward for our clients, but at the same time, what's the risk in doing that virtually? Is there, I believe, I guess, that there's a difference, not only in just kind of who's behind the camera and are you being coached and were you coached before this and, you know, something, but also, like, I think there's something to be said for, like, look me in my eye and terminate my parental rights. Look me in my eye and, you know, tell me I'm doing 6 years in state prison. And I think when we don't have those body cues, when we don't have, I don't know, the energy and presence. I'm from California, so, you know, I'm into energy and all that stuff. When we don't have that, how does that change representation for clients? You know, for all the clients that we're working with, it's, you know, vulnerable populations. What does that mean? Any other ideas or thoughts about how COVID's impacted in-person representation? Any housing folks out there? Anybody doing any housing work? I know there was somebody at LCBH. Not to call you out, but I think housing has presented some interesting challenges in a court that typically moves faster, or at CGLA if you're doing civil, if you're doing housing.
I'm at CJLA, and I think with housing, well, it's kind of good for our part, but like landlords has been unable to move forward with evictions. Mm-hmm. So that's been good for our clients because our clients get to stay. And mm-hmm. like right now, like cases, it's not much that you can do over Zoom. So like cases are either not moving forward. So right now they just at a standstill until court open back up.
Mm-hmm. Yeah, I think housing is one of the unique areas where our clients aren't getting evicted. And gives us, I guess, and our social workers some time to help figure out alternative housing options, right? Before. So yeah, thank you for sharing that. I think that's, you know, one of the more positive, I guess, things that have come out of this. All right, so the dispositional hearing. So this is, really asking, like, can we safely return this child? Are the parents fit, willing, and able to take care of this child or children? And this is also where we discuss permanency. So a lot of times a dispositional hearing and a permanency hearing will be set at the same time. They'll be heard together. So for permanency, you know, what's the most appropriate goal for the child? And so is that return home? Is that substitute care, which is foster care, which could be specialized, like if a kid needs like a specialized facility, kind of what does that look like? What's going to be the best for the child? And so these have to be the permanency hearings, and actually I think this slide is probably better. They have to be held, so these are the options for kind of what permanency looks like. The numbers are the months, so return home 12 is in a year, so do the parents need a year, or parent, guardian need a year to kind of continue to work on things, or can we do it sooner? Then, you know, or we kind of decide at this point, this is where, you know, it's really about, is this going to be a case where parental rights are going to be terminated? Or is this going to be a case where we can not terminate rights, and either the child will be placed with a guardian. So that's where the person that the kid is placed with gets to make educational and medical decisions, but the parent is still the parent. So I always try to prefer or try to push for guardianship over TPR if we're in a position where the parent isn't going to be able to care for the child. Or is it a return home, which that's what we hope for. But if that's not possible, then we try for guardianship. And if we can't get guardianship, then unfortunately it does go to termination of parental rights. So we do file motions to return home kind of throughout the case. We can file them at the beginning, at the end. It's a part of the statute. It's 225, 223, 224, and 225, 2-25. ILCS, I think 405. I will get it for you. I can let y'all know. But these are, they're called orders of protection. And so they're not your typical order of protection that, you think of with kind of domestic violence. Instead, they're these orders that have a list of conditions that the parents have to meet in order for the child to remain in the home with them. So a lot of times I describe it as like, these are what we would say, many of us would say are kind of like the, common sense type things. So don't be under the influence of drugs or alcohol while taking care of your child. In today's age, corporal punishment. So no belts, no whips, nothing like that in terms of punishment. Sometimes when it comes to punishment, there are some cultural issues and cultural challenges that we have to navigate with our clients. So that can be challenging. But there are all these other things. Sometimes if substance abuse was an issue, it might be that you have to do random drops for 6 months. So a whole list of things that parents have to do. Sometimes we can get an order of protection right at temporary custody. So if the judge thinks that it's okay for the kid to go back home, then they go home under this order of protection. Other times we file it at various stages in the case. So sometimes, maybe a parent, they've made a lot of progress in a short period of time. So we don't need to wait. And by short, it's relative short. So within a year, then we can we'll file these motions sooner rather than later so that we can get court dates and ask for kids to be returned home. So when we finally do a motion to close a case, we're hoping that we're doing the motion because the child was successfully returned home. And it means that there are no more outstanding services that the parents have to do. So if they had to do inpatient drug treatment, then intensive outpatient, then outpatient, they've done all of those. They've done individual therapy. They've done their parenting classes. They've done child family psychotherapy. They've done domestic violence classes. I will say that if you are assessed as needing domestic violence, whether that's perpetrator or victim services, those cases are some of our longest lasting because the classes that you have to do can span almost up to 6 months to a year. And so once we close the case out, we can then vacate our appointment. If we're not, the termination of parental rights is, and one other thing I guess I should say about closing the case is when you're dealing with teenagers, so kids that are, you all know what teenagers are, at times they can ask, depending on what the goal is. So if there's an independence goal, so maybe it's that the kid isn't going to go home to mom or dad, but they're aging out, they're getting older, they're 18 and they've gotten a job or they're in school and have a way to support themselves and they have housing, etc. Then they can actually ask that their case be closed. But they just have to come into court and say, I have my housing, I have a job, I'm in school, whatever it is that they need. There are some steps. And there are actually, a while ago, I learned that there are a bunch of classes that I think many of us probably needed at some point, like Finance 101. So how to, balance a checkbook and, what your bills are going to be and all that kind of stuff. So there are, DCFS is not the greatest parent, but and even though, you know, it's very adversarial and typically I'm fighting with DCFS, there are absolutely some good things that they do. So termination of parental rights is, you know, this is kind of the worst case scenario. It's when we get to a point that after probably, you know, 2 years minimum of working with a parent, that we just get to the point where the court is, or the state's attorney is asking that their rights be terminated, which means the child is then available for adoption. And, you know, it's tough on parents. We try and kind of hold it off as long as possible. And again, if we can prevent termination of parental rights and move towards guardianship, always better, right? We know from studies that, you know, kids, reuniting and being placed with a parent is so much better for both the parent and the child than foster care. You know, we know foster care has issues, and it is not, you know, this glorious, wonderful thing. There are some great foster parents out there and some, you know, wonderful things that people are doing. But foster care is never going to, it's never going to be a substitute for being with your family, right? So we're always trying to push to reunify families. And so with the overview, you know, there are often very contested. They can last for days, like sometimes 3 days. And they're bifurcated proceedings. So, you know, there are 2 parts to the hearing, to the hearing. And it's just a very long process. There are also, sometimes you don't always go to a hearing though. And sometimes I have had parents who have asked to voluntarily sign consents terminating their rights. And that is, you know, something that we don't do lightly, and we counsel clients through that process so that they fully understand, you know, what it means to give up your rights. Some of my clients who are incarcerated with 85 years, you know, that's someone who a lot of my long-term incarcerated clients will go ahead and if we can't do guardianship or kind of just depending on circumstances and situations, they will sometimes ask to just go ahead and terminate their own rights. So that's another way. So that kind of wraps it up for kind of the overview of the child protection system. I hope it was informative and kind of gave you a glimpse into how a case moves through the system, how they come into the system, some of the challenges that we face as advocates within the system. And if you have any questions or comments or concerns, anything, I've provided my email there. Feel free to email me and reach out. I think what y'all are doing is such great work for clients in such vulnerable populations. And I used to say to my team when I was supervising that, you know, our role is as legal aid attorneys, you know, it's not to say we're not here to save anyone, right? But we're here to walk beside these clients as they are kind of, you know, undergoing some of the most challenging times of their lives, right? And to treat them with dignity and respect as they navigate this complex and very intimidating legal process. So I think what you all are doing and what you've committed to do for this summer and those who are fellows is such wonderful and meaningful work for people who otherwise wouldn't be able to get the level of representation that you can provide. So y'all are doing great things, and I can't wait to hear and see what you continue to do.
Thank you, Kimberly. Does anybody have any questions with a minute or so left? So much time, but I'm sure Kimberly would be okay staying a little bit over to answer any questions.
So I actually do have a hearing.
Hard stop. Okay.
At 1, but yeah, so, but honestly, like, you know, feel free to reach out at any time. I'm more than happy to answer any questions.
Well, then there's Kimberly's email, and thank you everyone for joining us. Thank you, Kimberly, for that wonderful overview. Please, Sophia included the link to the evaluation form. Everyone, please fill those out. We love to hear your feedback. And then hope you'll join us next week for our session on Wednesday on the public interest career panel. So this is where we have 3 folks from legal aid and government talking about their career path and any advice for you all. So bring your questions to that as well. Thank you, Kimberly, and thank you everyone for joining us.
Thanks so much.